Mr. Wright, did you get yours going too?
Yes, ma'am.
Okay, cool. Ready, Whitney?
Oh.
Got yours going? Okay.
Oh, okay. If it's moved, I won't
It's moved.
We ready? All right, we're having this hearing to determine the fidelity of the challenge to Charles Wright's candidacy for the Republican State Convention. And do you want me to read this paper to you guys, or can you read it? It doesn't matter.
Well, it does actually. I would note that any recording minutes or recordings would have to be audible.
Okay.
So you do actually have to read it into the record.
So, this is to challenge Charles Wright's candidacy for Republican State Convention delegate within the meaning of Indiana Election Code 3-8-1-32, Precinct Committeeman, delegate to the State Convention. We note the 48-hour notice was post-timely by the Crawford County Clerk, and the candidate and challenger were duly notified. We note the presence of both Charles Wright and primary candidate for the Republican State Convention and R. Whitney Timberlake, the challenger to Mr. Wright's candidacy. Chase, can you introduce yourself?
I'm here in my capacity as Secretary of the Republican Party, as the chairman filed as the chairman. It is my duty per party policy and per 8th District policy to enforce the rules of the party. I'm not here in a legal capacity. I'm not here in a legal representative capacity. I'm here in my capacity solely as the Secretary of the Crawford County Republican Party.
Thank you. By way of introduction, the three members of the election board are Tony Clark, that's me, the chairperson, and Democrat representative. Carl Draper, he's a member and the Republican representative, and Lisa Holzbach is the secretary and I will be the presiding officer. Prior to the beginning testimony and submission of evidence in this matter, the election board asked the cooperation of the participants to abide by the following procedures. Number one, the candidate and challenger will each have 10 minutes to present the opening of their case. The candidate and challenger will each have 5 minutes for closing statements. The challenger will be first to open their case, and the candidate will present the second. The candidate will present their closing statements first. The challenger will present their closing statements second. Neither the challenger or the candidate will interrupt to the other during their presentation. Prior to the beginning of their presentation, the parties will identify name, title, and address of their representatives or witnesses that will speak on their behalf. Number 7, the board will entertain requests for flexibility in these procedures, and the board may ask questions for clarification. Number 9, following the testimony and presentation of evidence, the board will publicly discuss the matter and vote on the fidelity of the challenge.
I have a clarification, or a question rather. You will be reducing the decision of the board to writing and presenting it to the chairman and the respective candidate when this is over.
Will we? Yes.
We will certainly give the findings in writing.
Yes.
The recommended procedure from the election division would be you would present a copy of the minutes in this case being the recording of the event, and then whatever you reduce to writing, the decision thereof.
Can we make a declaration that each party is audio recording this meeting, that will suffice?
That would suffice it for me, but if you ever get asked about it later, I think you would want a copy of it to retain for your records, because the secretary of this board, the clerk, is required to keep a copy of the minutes for posterity.
So see, like when this is over, one of them or both, I'll have to have that to listen to so that I can write those down.
Well, can we prevail upon one or both parties to present the recording, either the recording or a written transcription of the recording?
You have to reply audibly.
Yes. Yeah, we're being recorded, that's right.
Okay, so Whitney has indicated he will provide us a transcript of the recording.
Well,
So as we can
provide
keep,
you a copy of the
let
recording.
me just interject one thing here so that we can keep the recording kind of understandable. I ask that the parties, before they speak, introduce themselves before they present any statements, so we can
Okay.
ascertain who's speaking at what time.
Sure.
I would second that the Indiana Election Division also recommends that the parties be introduced, and actually they recommend that you provide your name and be sworn in to tell. But that is, of course, your decision. Well, actually, your decision.
Well, let's do that. Does anyone have a copy of what I'm supposed to swear them in?
You just,
Affirm that each one.
you're actually the person who does this.
Okay, I would propose we just do it like when we're, the oath, you're under oath and here, like that. I would just tell them and speak their name so that we know who's speaking.
Charles Wright speaking. I said, just do you affirm that you tell the truth, the whole truth, and nothing but the truth? I do, as Charles Wright.
And Whitney?
Yes, I affirm that I will tell the truth.
All right. Good.
And I guess, okay, that's fine. I have nothing as Charles Wright, so we'll proceed on with the proceeding here. I do want to, this is Charles Wright for the record, I do want to, at this very early stage here, it's very critical in a legal standpoint.
Can we hold that till after we get the opening statements?
I'd prefer not, because this really would need to be a preliminary decision making before anything gets. It's just a preliminary motion to dismiss, and it's very simple, based upon the pleading that was filed. It's either granted or denied. If you all want this decision on it or have a rebuttal by the petitioner.
If I could interject before he submits this, I would note that an election board hearing is an administrative procedure, not a legal one. And a motion to dismiss would be more proper for any sort of judicial proceeding. And that would be the statement by the Republican Party to that effect.
And my name is Charles Wright. I'm going to respond back to that. It seems like Chase Smith is being in the capacity of a lawyer here, advising this council and this tribunal the direction.
I can respond that the board operates under delegated authority. We've been delegated authority under the Indiana Election Code. We truly are an administrative body, not a legal. We're not a court, and so in terms of dismissing, we have really no authority to dismiss. You have other options, but that's up to you.
So the motion to dismiss, to clarify, it's denied.
No, we're not going to rule on it.
Okay, at this time.
I'm not at this time, because that's not in the purview of our authority.
I just need to enter for the record. My name is Charles Wright, and I object on the legal grounds that was put in the motion to dismiss.
We have no authority to act under your assertion that we're acting under the U.S. Constitution. We're acting under the delegated authority. So
Just
anyway.
for the formal record, I have to enter my objection and keep things legal.
Gotcha.
Well, as the secretary, this is Lisa Hosepog. Mr. Wright here, he's put in this motion to dismiss. He filed it in
True.
my office as the clerk. And it has went in, he just came in and he did just file it. And I'm just wondering what I would like to hear his reasonings, that why he feels like we should think about dismissing it.
It still doesn't give you the authority to do it, though.
No, that's what I'm
So
saying.
then how is it relevant?
If I could interject here, I would.
I'm objecting to you interjecting.
Well, let's get back to
Let's do this.
the agenda.
We've got the challenger. He's here as secretarial position only, Mr. Chase Smith, and I requested he go through the one that brought the claim here. If he can do that, I can have my wife that's here with me also interject as my secretary, and we don't need that kind of thing. So to keep things down, let's keep Mr. Chase Smith silent on the record from here to 4. If he has something to say, he goes through the petitioner. That's his boss.
I defer to the presiding officer to maintain order in this meeting
Yes, sir.
and proceed.
Let's
the
just
agenda.
proceed. This is not, we're going by the Indiana election code. I'm not a lawyer, and we need to follow the code, and that's according to the state election lawyer that we call. We have to follow this code. And this is Tony Clark.
Okay.
Okay, as
We recognize R. Whitney Timberlake.
okay, I am Whitney Timberlake, Crawford County Republican Chairman, and as such, the person who filed the challenge here, I'm yielding my 10 minutes to Chase Smith, the party secretary, to present this.
I vehemently object that no more than I can have my wife represent me in this proceeding. Mr. Timberlake brought the claim. He filed it. It's his claim. He's appointing a non-lawyer to represent him in this proceeding, and I object to that.
I feel that Whitney should present this to the board.
If we need to take a vote on this matter, I believe both parties are entitled to representation.
It says that in the paperwork you just read to us.
Okay.
It has to be by a lawyer, though. It has to be a legal
I
lawyer.
agree with Carl.
And this was
You know,
done as
if
a
he
party.
wants, I mean, if he wants to appoint, just like if Mr. Wright wants his wife may have something she wants to
Sure.
say, and he can appoint her,
Okay,
I
so
don't have
it's
a
been
problem
voted
with
on,
it.
so,
Right. So the vote is 2-1 to allow representation.
I want to just, for the record, enter my objection to that, but proceed on.
Chase?
Yeah, I would note again that I'm not here in a legal capacity. I'm not here in a legal capacity of any kind as a member of the bar. I'm not here in that capacity. I'm here as the secretary of the party representing the interests of the party itself. And if you would note in the rules that were stated, I would be the representative speaking on Mr. Timberlake's behalf. Nowhere does it say I have to be a legal representative to do so.
Okay.
As the record needs to be audible, I will read the complaint into the record. The issue is whether the individual is filed.
I want to enter objection here.
We've already...
He's got a time limit that he has to respond, so he's reading something that we've all been served with, so he needs to present his case.
It also says you can interrupt. That was in the rules.
Well,
You're
I mean,
interrupting.
but he's taking more than his time because it's...
Well, you're taking
Okay,
his
all right,
time, so
let's go.
we
Start
agreed
over.
not to interrupt. So if you can start over.
My
Chase.
apologies.
The issue is whether the individual that is filed is qualified to be a candidate for delegate to the state convention. Qualifications for delegate to a state convention are listed in Indiana Code 38132, herein attached as Exhibit A. These qualifications state that the candidate for delegate to a state convention must comply with any candidate requirements set by the state party rules. The eligibility of Republicans to serve as Republican Party delegates to the state convention are governed by the rules of the Indiana Republican Party. The most recent rules of the Indiana Republican Party were adopted on March 11, 2019, and are available in their entirety at an attached HTTP address that I'm not going to read. Eligibility requirements for state convention delegates are found in Rule 7-8, here and attached as Exhibit B. The relevant rule reads in part that no person shall be eligible for election at the primary election for the office of state convention delegate unless the individual is a qualified primary Republican. The definition of a qualified primary Republican is found in Rule 1-24, see Exhibit B, which states that a qualified primary Republican is a voter who cast a Republican Party ballot at the most recent primary election in Indiana, which the voter voted, and the emphasis was added here, who is a Republican in good standing. The definition of Republican in good standing is found in Rule 1-25, again, Exhibit B, which states that a Republican in good standing shall be defined as a Republican who supports Republican nominees and who does not actively or openly support another candidate against a Republican nominee. There is documented proof that the individual in question has a history of not supporting Republican nominees in support thereof. Attached are Exhibits C through J, in which the individual refers to various Republican nominees as a, quote, whoremonger, being foolish, and no morals. Raunchy, the worst prosecutor in Crawford County history, and a coward or unqualified. In addition, the individual takes great care to identify Republican nominees by name and office and accuse them of committing a number of state and federal crimes. That's Exhibits I and J. It is worth noting that a person becomes a nominee after being formally nominated. In the case of the statements made about the individuals, the subjects were either already office holders or the nominees of their respective offices. Even after being elected, they remain the nominee of their parties. Because the individual is not eligible per party rules to serve as a delegate to the state convention, he should be removed as a candidate for delegate to the Republican State Convention. In addition to that, I would just say that the rules are pretty clear. That this is not a decision over whether somebody does or does not have years of residency to live somewhere, or does not have the degree necessary, or is admitted to the proper organization to be. The legal issue here, the issue according to the code, is whether it is fully delegated to the state party rules. And the state party rules are pretty clear. Party Rule 124 says a qualified primary Republican, it has to be a member in good standing. Rule 125 says a Republican in good standing has to support Republican nominees. You can see through the various attached exhibits, when you refer to somebody as a whoremonger, or when we get to my personal favorite here at the end, when a Republican nominee, actually two of them, were accused of violation of RICO laws, violation of state and federal constitutional rights, manipulating election count, which would be a level 6 felony, by the way, a criminal manipulation to prevent or interfere a candidate for elected office, treason, embezzlement, extortion, violation of equal protection, so on and so forth, and ad exhaustion. The issue here is the party says that he would not be a qualified candidate. If you were to further read the party rules, they would say that somebody who's not eligible to serve as a delegate to the convention would have a challenge, or could be challenged by the Board of Credentials, a sitting board for the state convention. They would then decide, based on the evidence presented, that he would not be eligible. Therefore, they would not. Crawford County would be one delegate short after the convention. In short, I'd say this: the Republican State Party says that he is not a qualified candidate. The chairman, by filing this petition, says he's not a qualified candidate. I say he's not a qualified candidate. It is fact. And so we would just ask you to adhere to the statutory rules and remove him as a delegate to the state convention. That's all I have.
Okay, 4 minutes.
Mr. Wright, whenever you're ready.
Give me just a
Okay.
second here.
For the record, we have no problem. We don't want that to be deducted from his time anytime that he gets to prepare.
Okay, thank you. Let me give you a copy of those documents there, and give all the members here. My name's Charles Wright. I'm handing out copies of documents that's for evidence. There you go, Miss Holzcroft. And there's that. See, that's no, it's that's still giving out these documents. This is the last one. Okay. Did you get a copy of the first stuff that I gave? That's that. Here's your all's copy. I'm sorry. There's that. And there's that. I think
We got that.
Okay. All right. All right, now I'm ready to proceed. May it please the board, after reviewing the Indiana GOP rules of the Indiana Republican State Committee dated March 11, 2019, the statements and allegations in Mr. Timberlake's complaint, there is no evidence from the date of my 2020 candidacy that I violated any rules that would disqualify me herein. upon the evidence submitted here today, you will find that what I just said is true. The Indiana GOP rules of the Indiana Committee, it's very clear that it states these are rules for the state convention and applies to elected delegates, committeemen, and people that when they go to the state convention, they must abide by these rules. They're trying to apply these rules to me prematurely because I'm not a delegate, and therefore, elected people has a certain code of conduct to operate by. They're implying. To put it simply, the 2020 election primary has not been held, and the 2020 Republican nominees are not yet known. Mr. Timberlake wants you to remove me as a candidate because I am his and his father's only competitor for the county surveyor and their biggest competitor for the convention delegate in the 2020 primary election. For merely opposing and criticizing local political bad actors and actions in both parties prior to my announcement to be a nominee and a candidate in the 2020 primary. Mr. Timberlake's dirty tactics to have you disqualify me from being a delegate is just one of the many reasons why I'm running for elected office in Crawford County. Let it be known, I will support the 2020 Republican nominees and that I have not, since my declaration, actively or openly supported another candidate against a 2020 Republican nominee. Very simply because the 2020 primary has not happened and the nominees are not known yet. Further, any history prior to one's declaration of candidacy has no relevance here based upon the laws and the rules, and is clearly and simply established by the laws and the Republican Party's Form IRSC-CA-1. Unless this board is going to hold me to a different standard of review, and that in and of itself would be morally wrong and expose and or create a gross violation of the law. Now, the document of the document of the IRS CA1. If you can look at that, I can pull it up here. Find it in my copies. It states, they have Democrats come over. They're allowed to come over and switch parties. And they of course, they blatantly oppose candidates from each other's party in prior elections. But if they allow them to come over, they're certifying that they are in good standing, and they can run for office. And that's what this is about, being able to run for office. I have filed. Let me give you mine. No, I'm looking for my, I gave you my certified copies of where I filed for office, correct? I just want to get that on the record, that I've shown where I filed for office. You all got those copies, correct?
Yeah, we have those.
Okay, that's certification. I am in compliance with all laws to be a candidate and run for public office in both categories, the surveyor and to be a delegate. And at which time I'm elected as delegate or appointed, I think it's automatic, and it shows that he's a conflict of interest. He's certainly coming in here with a challenge in my candidacy, try to knock me out of being a delegate. But it's just all premature and it's wrong, and his petition should be denied, and that's all I have right now. So thank you for your time.
Okay. 5 minutes.
Thank you.
Okay. Now, you heard their case. It's now we've set aside 5 minutes for rebuttal or comment, so you have more time, Mr. Wright.
Okay. I said, I submit that we're here prematurely and wrongfully, and he's trying to have me held to a different standard of review prior to me being elected delegate. and that he's trying that just by the sheer virtue of nobody would be able to oppose. I'm only opposing these people. If you cannot oppose or criticize anyone for anything, then our whole this county and this whole country is in problem. It doesn't prevent somebody from opposing and criticizing their own candidates for things that they do wrongfully. It cannot throw them out of office. It should not. And they're trying to get you all to do this and to bar somebody from running for office to try to make things better. Mr. Timberlake and his father and others have been sucking this county dry for decades with these kind of tricks and shenanigans to keep good people out of office and for doing things for the county, good for the county. Thank you for your time and attention and consideration. I'm done.
Okay. 2 minutes. This is Woody Timberlake, County Chairman. Got a couple quick comments. One, if I was just trying to stop any opposition, obviously I would have filed a challenge on the county surveyor too, because that's one of the arguments is that I'm trying to stop my dad or I have an opposition. That's definitely a bigger race. I did not challenge that at all. I will also note that I did not file for state delegate till after Mr. Wright did, because I did not want him to be opposed, or I didn't want him to be unopposed. I had not previously planned on filing, but he would have been automatic if I had not got this challenge filed. Those are my only comments, and I'll yield the rest of my time to the party secretary.
I would make a couple of notes, a couple of corrections. We're not implying that he was speaking ill of the candidates. We were stating it outright. And you heard him say he was speaking ill of Republican nominees. Those were his words that he used 3 minutes ago. I would also note he referred to the IRS CA-1. That document has no relevance here. That applies to somebody who doesn't have a voter history or somebody who had previously voted with the other party and wishes to be noted as a member of good standing. Even if he was a member of good standing within the Republican Party, that wouldn't have anything to do with convention delegate. It is a true statement that people should speak truth to power. We've never said otherwise. I agree wholeheartedly with that. But there is a time and a place. The issue is this is not about a candidate. If it was in his capacity, if it were simply a candidate for surveyor, he can say whatever he wants within the bounds of the law. This has to do with being a candidate to the Republican State Convention. This is the lifeblood of the Republican Party. We govern ourselves the way we govern ourselves. It is a private organization. That's why donations to the Republican Party are not tax exempt. That's why we operate the way we do. And our party would not accept him as a delegate for the reasons that I've stated herein. And because of that, we're asking you to remove him as a candidate. Now, I would also note, in one of the documents he handed to us, he marks Reginald G. and Reginald W. Timberlake. I would note that Reginald G. Timberlake is not actually in the 9th district where he would be running. He's actually in the 8th district. So the candidate he'd be running against would actually be Whitney, not Whitney and his father. Anything else? So I would just ask that you guys uphold our challenge and remove him as a delegate. Remove him as a prospective delegate to the state convention.
My name is Charles Wright. I just have one correction I'd like to get made. He stated that I spoke ill of Republican candidates. I opposed and criticized a lot of people in office for their wrongful actions. What I feel is wrong, and oppose wrongful actions. What I view as wrongful, and that's the freedom of this country. Now, he's trying to interject that I said I spoke ill as a misstatement. That's all I have.
Okay, it's time for the board to deliberate and defer to our presiding officer as to who's going to go first, but we certainly need to.
Do you guys want me to trade seats with her so she's over here next to you guys? But that's up to you guys.
It's up to her.
We started you comfortable.
I'm comfortable. It's
Okay.
Lisa, I'll let you go ahead and start.
Can I say one thing? This is Charles Wright. If the board would have any questions they would like to direct to any of these parties, I wouldn't be opposed for you to get clarification if you need it
Okay.
before you make your decision.
I only had one issue, and during your presentation, Mr. Wright, you indicated 2020 from the point of your candidacy forward. You have been a model Republican.
Yes, sir.
Or you've not spoken ill. But the issue before the board may go back prior to that, so I just wanted to make that clarification.
Well, I really don't, I think that's fair because other candidates coming over crossing party lines, they certainly have opposed and criticized candidates from the opposite party, and when they change parties and go over, they are given a pass from previous statements.
Certainly.
And that wouldn't be real fair if you'd done that.
One comment I'd like to make, this is Winnie Timberlake, the chairman. If anybody's came over, they were in good standings. They weren't insulting, criticizing. There wasn't a problem there, or they wouldn't have made that transition. There's nobody that there's an issue with that makes that transition. It's someone who's has a good position coming into it. It's definitely not anything like this.
Well, my
just do
response
one
would be every case has to stand on its own merits. Sure. And we're not bringing in other candidates into this. This is this situation.
Let me just say this. If all the current candidates and have been just model candidates and just doing everything right, nobody would need to run for office because, and that takes out of the play or the election to let the people decide based upon their actions previously and going forward. I mean, everybody has a right to oppose people and criticize them. It's not illegal.
And we're not even concerned about that.
And that's all I've done. Just oppose and criticize. And they may not like my wording or something like that and the other, but
I think we've all had our time.
Yeah, we certainly.
okay, thank you. I'm sorry.
So I guess Lisa, you deferred to her to go first discussing this matter.
Well, I'm probably going to need a few minutes to go over this, maybe listen to this myself and go through it.
Would you all like us to leave the room so you all can do your decision?
This is public. I think everyone needs to
If Lisa needs more time to consider it,
Only because
certainly am willing
anybody
to go.
that knows me, it's like, it's going to come from my heart and what I really feel is right, regardless of what party it is or what's going on, Whatever decision, it's not going to be an easy one. I'll just let that be said. But whatever decision I make will be the right one. But before I can make a decision, I want to listen.
Let me say one thing.
I didn't even look through
Let the
any
people
of the
decide.
paperwork
Let the election have it.
I did not.
And let them do their thing.
That's not why we're here today.
I have Facebook.
So,
Carl, do you want to go ahead?
I
Not
would.
long, just a few minutes.
I have had an opportunity to look at what's been filed, and I would, when I look at the candidacy, declaration of candidacy, this Can 37, I was struck by paragraph 4, the assertion by Mr. Wright. Says, I comply with all requirements under the laws of the state of Indiana and any candidate requirements set by my party's rules to be a candidate for this office. So you are swearing, you took an oath, that you comply. What the board is required to do is to apply the Indiana Election Code 3-8-1-32. And it says, in short, a candidate for delegate to a state convention must comply with any candidate requirements set by state party rules. So we're in agreement with those forms and the code. The rules, I believe Mr. Wright challenged whether the rules apply to him. I would refer Mr. Wright to Rule 1-7, which says every person, which would include everybody here or everybody at the Republican Party, member, officer, or delegate of any committee or convention by their own act of seeking or accepting the election or appointment to the party organization or convention expressly agrees by this act to accept the privileges, responsibilities, and penalties granted, imposed, or provided for pursuant to the law and these rules. So the rules back up section 38-1-32. We did hear a citation regarding the rules as to whether or not Mr. Wright is a qualified primary Republican, and it's stated here in the party rules, a qualified primary Republican is a voter who cast a Republican Party ballot at the most recent primary election in Indiana, in which the voter voted, which he does comply with, and who is a Republican in good standing. And we heard by testimony and cited in Rule 125 in the GOP rule book, the term Republican in good standing shall be defined as a Republican who supports Republican nominees and who does not actively or openly support another candidate against a Republican nominee. This rule does not put a time frame on when you actually supported or did not support a nominee. So from 2020 forward, you're telling us in your testimony, Mr. Wright, that you have supported nominees. You have not, you haven't disparaged or not supported them. However, it does not put a time frame on it, so we've got to look at recent history. When I look at recent history in the testimony, I find at least one instance where it appears you stepped over the line in terms of these rules. And here's where I would like to bring this issue up. And it has to do with nominees.
Nobody's nominated yet.
Oh, well, we're not looking at 2020. We're looking...
The time I signed that statement, I mean, from that point,
I'll let you respond as soon as I finish. Approximately 6 weeks before the 2018 election for prosecutor in Crawford County, Mr. Wright, it appears that you posted on Facebook that Nick Haverstock, who was a nominee for prosecutor, is the worst prosecutor in Crawford County, Indiana history. That was posted on September 25th. 2 days prior to that, 6 weeks prior to the general election in 2018, you posted on Facebook, Haverstock is a coward or unqualified for refusing to prosecute Oleges for hate crime murder. So the question is, are we just casually criticizing or actually not supporting a Republican nominee by saying they're unqualified to hold office?
You want me to respond to that?
No. We also have a number of issues, and the party rules do not say anything about office holder in terms of how you direct your comments. However, we have comments directed towards Republican office holders that call them dirty, whoremonger, raunchy. those are not terms of endearment, and I would think that that might cause them some problems in future elections. But that's not the issue. The issue for me is the criticizing a Republican nominee 6 weeks prior to a general election goes over the line. And so that's where I come down on this case.
Did you say you was going to let me respond?
Now you may respond.
Okay. Thank you. My name's Charles Wright. The documents you were looking from, I mean, I don't know where, really, I don't know that them to be accurate because I don't know who printed them and copied them, and I can't testify to their authenticity.
Or that he posted them.
Or that I even posted them.
So are you denying that you posted them?
I cannot ascertain from the documents that you have in your file that you're referring to that they are accurate documents reflecting what I may or may not have posted on the internet. And I just have to look at that. I mean, you're going to have to draw that the authenticity of what it was given to you by the petitioner. And I there again, that's all I have.
Can I ask a question just
Sure.
to jump in here? It's like I'm sitting here and I'm looking through some of this stuff, and whether it be authentic or not, it's it's Facebook on there.
Or even whether I posted it.
But the only thing that I'm seeing is, the Republican candidates, except for this one here done in 2016.
That hits everybody.
It hit everybody, but are these on here, and like you said, is it whether you did it or whoever did it, that's, it's under your name, and, and
From the time that I signed...
Let me finish just for a second, and then I'll let you speak. Is that a lot of things go on Facebook, but there's a lot of stuff on there. It's like Judge Bale, and the things that happened with her and Nicholas, and but I think that would be up to the courts to decide, like putting it, to get it out there. Some of the words, I know Sabrina personally, and I don't know, maybe I'm thinking some of the words were a little harsh. I'm not saying that you did them or anything like that, but to be a candidate, you do have to be upstanding. The community, like our children and everybody else, they look up. You're going to be somebody's hero. You're already, your wife, if you were to run in this position, somewhere down the line, it's going to be somebody's hero.
And that goes to my point that, from the time that I signed the paperwork to become a candidate, and especially if I'm elected as a candidate, I am bound to rules, codes of conduct. But the freedom to oppose and criticize the people in office doing things that you perceive to be right or wrong, or in this case wrong, it's got to be protected. But once you are the representative of your county and there is a code of conduct that you must adhere to, and they are rules here, and that's what the book is the rules he's entered on that would prevent me from getting out of line. They can have me removed. And there's such thing as impeachment, and that's, Lord knows, we've been going through impeachment process with our president. And there again, there's been Republicans oppose him on that. They're not throwing him out of office because he's, but anyway, that's just an example. But anyway,
We're not here now. This is Tony Clark, and we're here to follow the code book. I brought a copy of the Constitution. We're not debating your First Amendment rights. This is the Indiana Code that we're having to follow. If it was for any other position, but where I am taking issue, and I agree with Carl, is that you're representing the Republican Party. And it means a lot when the chairman of the Republican Party objects to you running. And I mean, we've read the code. I don't do Facebook. I don't believe in Facebook. So this is the first time I've seen any of this. But like I said, we're not here to debate your First Amendment rights. You're here to represent Crawford County Republicans as a state delegate, and it's a pretty big deal. And when the chairman objects to it with all the findings, I'm really inclined to agree with Carl.
Can I respond to?
Mm-hmm, sure.
Where's the people at? Let them vote and make the decision. And I would be bound. I'm bound by these rules. I mean, yes, but to prohibit me, it's like you're taking my right to run for public office just because what you've been told that somebody said or been presented here. I mean, and even so, I mean, but it's opposing people. Even if it is true, it's just opposition to conduct of people. The right for the vote to have. If I'm not allowed to run as a Republican delegate, how can I be allowed to run as a Republican for the surveyor's office? It can't be done legally. Now you all can administratively throw me out there and let me go through the hoops, and that's what I can do, and that's what I will do. Because it's wrong for you to short circuit my right to qualify and run as a candidate and be elected by the people, not by some administrative board trying to penalize me for campaign opposition and criticism. It's asinine. We're here on something asinine. And it's morally wrong, and it's legally wrong. I rest my case.
One comment along the rules here. We've had a hard time. It says you can ask questions, but we've had our time. Someone who's so worried about the laws and the rules, I think would quit talking because the rules are pretty clear here.
I only follow up on your comment about this case filed in 2016. I didn't consider that because it was filed
It was
against
the last
Republicans
page,
and
and
Democrats.
I gave them back. I gave them back
So
over there.
we
It's on the
didn't
very
have-
last page.
Yeah, we didn't have the
Right.
copy of the ruling or what transpired, so
Yeah.
I just...
And nothing did. It was just like Whitney had spoken. He said it was just pretty much so on all of them. And what I'm saying is this just wasn't a one-time thing. I'm seeing consistency, and whether I agree with it or, we have to follow what is in the election. That is what we are hired, to do. That is our obligation. And like I said, as a candidate, of our county, I do feel we lack in a lot of areas, but hey, but this is pretty cut and dry here. But if you read this,
Vote your conscience, and let's move on.
Are we gonna?
Yeah.
Is everyone ready to vote?
Okay.
I'll go last. Go ahead.
Actually, procedurally, you would ask for a motion and a second. And
All
then
right.
would vote.
I'm asking for a motion to vote.
I make a motion that the Crawford County Election Board vote on this matter before us regarding the challenge of Charles Wright.
I second that.
Okay.
To be a delegate.
To be a delegate.
Vote your conscience, and let's go. Thank you.
Well, my vote is to uphold the challenge.
My heart tells me I gotta stick with it. Just there's a lot of accusations there that was wrong. So I've got to I've got to agree with Carl.
And I third that.
there's a lot of conduct that's wrong, and I'll never stop talking about it.
We just strive to do better.
Good luck, people.
All right, the meeting is now closed.
Well, it's all closed.
Okay.